Recording in progress.
Nothing happened yet, I think.
Okay.
You may start, Professor Luís. It's recording. I think he froze. You may start, Professor Luís. He's recording.
Here again, and I'd like to say that is a very interesting, and I learn a lot with Professor Bruno Simma. Professor Bruno Simma, it's a pleasure to be with you. The floor is yours. Thank you.
Thank you, Luís. Thank you very much, and good morning to everybody in the audience. As usual, yesterday I spent too much time on too little not substance, but too little stuff. So I'm going to hurry on a little bit and immediately continue in my program. You will remember that yesterday I tried to describe the increase in ICJ treatment of human rights matters from cases in which they were mentioned but not dealt with further, to cases where they played a certain role, etc., etc. And at the end of yesterday's lecture, I described the gradual build-up and the genocide judgment of 2007 as the last decision. And with this, we reach a number of really core human rights cases that were decided more or less in the last 10 years. And the first of these cases is the case of Mr. Ahmadou Sadio Diallo. Diallo was a businessman from Guinea, the African country Guinea, and he had invested in the Democratic Republic of Congo. And he was not lucky in his business, etc. And one day he ended up in prison. His company was more or less expropriated. And for reasons that he probably had good connections to his home country, because Guinea brought a case against the Democratic Republic of Congo to the International Court of Justice. Now, some of you might have heard about investment arbitration as a big industry, actually, in the last few decades. And when you look at the Diallo case, you must think this is really a case which didn't belong to before the ICJ. This was a case where an investor alleged that he was treated in breach of international law in another country, and that is the situation where you go to the Permanent Court of Arbitration or to ICSID and start one of these famous or infamous investment arbitrations. But for some reason, Guinea went to the ICJ, and the ICJ looked at the case and it threw out the really economic law questions which had to do with the treatment of Mr. Diallo's companies and focused on Mr. Diallo's individual human rights. And so the case, which is really not, if you look at the facts, it looks like cases of thousands of people around the world and maybe dozens of investment arbitrations. But the big thing here is that for the first time, the ICJ dealt with the human rights of one human person, this businessman, Monsieur Diallo. And the court found that indeed Mr. Diallo's individual rights had been violated by the arrest and detention of him, by the way he was treated in prison, etc., etc. So this was the first is focus on one individual's human rights. Second focus, for the first time in its history, the court referred to decisions by other human rights institutions, especially at the United Nations, but also the European Court of Human Rights. You probably think, isn't that the natural thing to do? that one court refers to the judgments of another. Well, that might be what happens in your country, but it doesn't happen much with courts that consider themselves to be really, really imperial, the highest. So you can look at the Supreme Court of the United States, where there's a big issue whether it should refer to, let's say, European court decisions. And the same situation at the ICJ. The ICJ never referred to other court decisions, and it did so for the first time here. So I think that's another signal or another indication that the court is becoming a bit more, let me say, human in a human rights context. It just behaved like courts usually do. So that was the case of Diallo, which was decided in 2009 or 10. Then in 2011, the court decided the case which I would consider the case I disliked most in my 9 years at the court. It was a case brought by Georgia, not the woman's name, but the state that had in 2008 been engaged or had engaged Russia in an armed conflict, which didn't go well for Georgia. And so Georgia was more or less lost a part of its territory to that, which is now under Russian control. Georgia defended itself with going to any court it could get a hold on. And one of these courts, for some is a judicial warfare was the ICJ. And Georgia complained before the ICJ that Russia had breached the Convention on the Elimination of Racial Discrimination by treating certain ethnic groups and populations in Georgia that were living in regions of Georgia that the Russian troops had occupied, by displacing them, and so on and so on. I have to say that you can really imagine the legal team of Georgia trying to do something to defend the country against Russia at the legal and desperately. You might have heard of that movie, Desperately Seeking Susan. And they were not desperately seeking Susan, they were probably desperately seeking a treaty on which they could base jurisdiction. And so they ended up with CERD. The situation is a little comparable to a case that you now have before the ICJ, where Ukraine also sued Russia for violations of CERD, which had to do with the treatment, which has to do so-called Crimean Tatars, that is an ethnic group on Crimea. So what you see in a case like this is, it's not, of course, the case turns around the people, the Crimean Tatars, these Georgians, but behind there is actually the real intention of the case is to add a juridical weapon in some kind of armed conflict or former armed conflict against another country. Now, the ICJ rendered provisional measures in 2009, and I think 2008, actually, in October, which it directed at both parties. So it said, you Georgians and you Russians, please keep from doing, etc., until I have rendered my decision. And then the next stage in the procedure was to see whether the court had jurisdiction. And so the court looked at the Convention on CERD, on the Racial Discrimination Convention, and the Racial Discrimination Convention provides for the jurisdiction of the ICJ, but it says in article in the 20s, I think 20, it says that you have first to fulfill the condition to engage in negotiation with the country against which you want to bring the case. And so the then president of Georgia, the government of Georgia, had indeed tried to enter into negotiations with Putin, with the Russian, with Putin, but Putin had simply refused to even talk to these people and said, if I catch you, well, I'm not, actually he used wording which I probably won't use because of the public. You are too young for this. So, and the court arrived at the decision that indeed Georgia had not done enough. It had not entered into serious negotiations, and therefore the precondition for seizing the court had not been fulfilled. This was a case where I not only took part in a joint dissenting opinion of a number of judges, but wrote a 40-page separate opinion of my own, because I took the view that Georgia had done enough. They should have accepted jurisdiction. But would be an interesting topic to see whether in regard to jurisdiction or in regard to finding whether the conflict has actually arisen, a dispute has arisen when the court makes differences depending on what country there is on the respondent side. But that is another matter, and I don't want to make statements that I cannot really prove, of course. So this was a case which disturbed me a lot. But then we arrive at two cases that are very, very, let's say, positive from the viewpoint of public international law and human rights. And first is the court of the case brought by Belgium against Senegal, the African state of Senegal. The case is called Questions Relating to the Obligation to Prosecute or Extradite. There the problem, so the facts were that you had in the Chad. Chad is a Central African state where in the 1980s you had a dictator ruling the country, terrorizing the country for about 10 years, with lots of people being killed, tortured, and quite a few people leaving the country and fleeing, seeking asylum in Europe, some of them in Belgium. Then at the end of the 1980s, Habré, the dictator, was driven out of the Chad, and he went to Senegal. Senegal granted him asylum, and Habré lived there under quite comfortable circumstances. But of course, the world looked at Senegal and said, Senegal, are you going to do something about this? And there is a treaty which is applicable in that situation, which is the United Nations Convention Against Torture and Other Forms of Inhuman and Degrading Treatment, the UN Anti-Torture Convention. And the UN Anti-Torture Convention does not just prohibit torture. It says that states are under an obligation to prosecute or punish torture, which means if a person is on your territory, and there is a how should I say some at least founded accusation against that person that he or she has engaged in torture, then the state is obligated to either start criminal proceedings and see whether this is true, and if it's true, either to punish. And if for some reason the state does not want to do that, the state is under an obligation to extradite if another state wants to do the punishing. Now, this other state was Belgium. So Belgium went against Senegal on the basis of the Torture Convention, which is interesting. It was the first time that one of the classic United Nations human rights treaties, CAT, Convention Against Torture, was before the ICJ as the jurisdictional basis for a case. Now the question is, why Belgium? Now, there are two, let's say, limbs there. The first reason why Belgium went to the court had to do with following circumstances. Belgium has a judicial institution which is called les juges d'instruction, which means things that in other countries public prosecutors would do, for instance, deciding whether to bring a case before the judiciary, are in Belgium taken by a branch of the judiciary, the juge d'instruction. These juges d'instruction are maybe a bit on the younger side among the judiciary, and being younger means a bit more courageous and probably also more human rights minded and educated in this. And so you had a number of cases, I'll get to another one later, where Belgian juge d'instruction went to the government and said, listen, you have to do something because I'm going to render what is called an international arrest warrant. So they rendered an international arrest warrant against this dictator Habré sitting in Senegal and said, listen, if you don't get your act together and engage in a prosecution of Habré yourself, then we are going to do it, and please deliver Habré to us. Now, there was a big back and forth, and of course, African countries were a bit concerned about, Belgium being one of the colonial powers with a terrible past, especially in Africa, etc. And always the Africans always singled out. You probably heard about the problem with the International Criminal Court had for a long time, when states complained and said, this is all going against us Africans. How about going against the British in Iraq or the Americans in Afghanistan? Okay, so they went to the court. And now for us international lawyers, what is interesting is that a product of the International Law Commission, a very interesting product of the International Law Commission, was applied for the first time. Now, I'm proud to have been a member of the International Law Commission when this subject was deliberated and adopted. It is a provision which says that if a breach of international law occurs, certain states have the right to invoke that violation and go against the violator and demand return to legality, invocation of an internationally wrongful act. And there the international law articles on state responsibility provide for such an invocation, a right to invoke by a state which has been individually injured, which is nothing remarkable. But the remarkable thing is that there is another article, namely Article 48 in the ILC articles, which says that states other than injured states can also invoke responsibility under certain circumstances, namely, for instance, on the basis of a treaty which embodies a common interest, a collective interest of a community, and the invoking state is a state party to that treaty. And that was one limb for Belgium. They said we are states which kind of want volunteer to litigate a common interest, the common interest of the international community, that grave violations of human rights be punished. The other limb was a bit more a traditional limb, because the juge d'instruction had been, or the attention of the juge d'instruction to what had happened in Chad had been, let's say, started by former citizens of Chad who had fled to Belgium and had become Belgian nationals. For the international lawyer among you, an interesting problem, namely, can a state do something for its own citizens? Yes, of course. But can a state do something for citizens of another country at the time the violation of international law against these other people occurred? Very problematic. And the rule of international law would have been that the Chadian the Belgian nationality would have been there all the time. So the state cannot engage in protecting a person, a foreigner, just like that. And so but they said, no, I mean, they have been Chadians, they are now Belgian. And of course, if a state protects its own nationals, you don't need this international law commission construction of states not individually injured going to the court, because you have an injury on Belgium because its citizens had in the past been mistreated in Africa. And the court decided in favor of Belgium in 2011 and decided that indeed the treaty, the Convention Against Torture, gave rise to obligations erga omnes. So, of course, in Latin America, you have Latin even in the name of the continent. So you don't have the problems with Latin that people had in the International Law Commission. I remember when we talked about how to name something in another article of that draft on state responsibility. And then it turned out that the term erga omnes was too complicated and too confusing for members of the International Law Commission, and therefore we circumscribed it in English. So if you look at Article 48, you don't find the expression erga omnes. But of course, the ICJ didn't have a problem, and he said the Torture Convention gives rise to rights of states to go against breaches of obligations erga omnes, and it added erga omnes partes, which means partes being parties, violations committed by other states parties to the Torture Convention. And so this was a very important development, because the ICJ jurisprudence had hitherto been, let's say, marked by this only a state which is injured, only a state whose rights were violated can go to the court. There is no actio popularis in public international law. And you remember yesterday, I spent a minute on the Southwest Africa case, where Liberia and Ethiopia made that experience that the court said, well, unfortunately, you're not individually injured. The League of Nations would have been injured, but the League of Nations is dead now, has been dead for 30 years at the time. So this is really, you can say, a recognition of the legal consolidation of a community interest, that decision of 2011 in the case of Belgium against Senegal. We have at the moment a case which is a bit similar before the ICJ. I'm sure you have heard about it. It is the case that the Gambia, it's called the Gambia, which is a very small state on the western coast of Africa, brought against Myanmar. This case goes back to the mistreatment of a minority in Myanmar, the so-called Rohingya, which from 2017 onwards, or actually 2016 onwards, were terrorized, killed in large numbers, tortured, and made to flee into the neighboring country, Bangladesh. One of the reasons being that the Rohingya are a Muslim ethnic group. Bangladesh is a Muslim, let's say, is an ethnic country, and Myanmar is not. Okay, the United Nations investigated the situation. And then the Gambia went to the ICJ. Why the Gambia? And this has a number of reasons. So one important member of the UN Commission, which was sent to which was sent to Myanmar to look into the situation of Rohingyas, was a high politician from Gambia. So that was one reason. So Gambia regarded itself as some kind particularly affected. But then you had a group, you have so-called Organization of the Islamic Countries, an international organization of the Islamic countries, and they supported Gambia. And because Gambia is a very poor country, so all the money for that litigation, etc., comes from other sources. And one of the sources is a organization of states whose majority populations are Muslim. And the Gambia claims violations of the Torture Convention. Violations of the Convention Against Genocide. So again, we have a genocide case. Okay. Now, the court has a few months ago probably a year ago, rendered a provisional measures in its current. The parties are currently working on their briefs on jurisdiction and admissibility. But already in its decision on provisional measures, the court recognized here again we have to do with a treaty, the convention, the Genocide Convention, which is a convention embodying obligations erga omnes partes, and it spoke in favor of the standing of Gambia in a case against Myanmar. I mean, maybe this doesn't look so exciting about you or problematic about you, but for a let's say a more traditional international law is a bit like law between big landlords, like big farms. And you see, you mind your own business. You see that that the neighbor doesn't set the boundary, how should I say, stones different, doesn't steal your horses, etc. But otherwise, it's not your business if another 100 miles down south something happens to one of these landowners. So this is a very bilateralist or individualistic view of international law. And so this idea, no, we can actually take another country at the other side of the world before the ICJ without our own nationals being the victim of a human rights violation, because there's nobody from the Gambia in Myanmar. This is a new development, and it meets a lot of resistance. For instance, if you look at this, also happened already in the Belgium against Senegal case. When you look at the opinions of the judges, you see that there are opinions by the Russian judge and particularly opinions by the Chinese judge who come out very strongly against this construction of obligation erga omnes for the protection of human rights. But the court says, yes, this litigation is admissible. But of course, you have to establish two things beforehand. You have to establish the jurisdiction of the court. Remember our example of the case of the Congo versus Rwanda yesterday. So jurisdiction, and secondly, there has to be a dispute between the countries. What cannot happen is that suddenly, like in the German Foreign Office, some humanitarian spirit breaks out like a virus, and Germany says, now we're going to take Myanmar to the ICJ. No. The ICJ would say, listen, you have not established that there has to be a dispute. If one country sues another country before the court, this is in order to kind of get a dispute to the judicial level. And then you have to prove that you engage the other country, that you invoke the responsibility, that you try to negotiate, etc., etc. And again, in square brackets and slightly, then I say that this is actually a way for the court to get rid of cases that it really does not like. So one way out of a situation where the court would be very uncomfortable would be for the court to say, this is great, yeah, this is awful, I mean, violations of important treaties, blah, 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 but you have not proved that there is a dispute between the two of you. And something like this happened a few years ago before the ICJ, when the Marshall Islands brought cases against the nuclear states, the states possessing nuclear weapons, and tried to litigate, or let's say, and alleged that the nuclear powers had breached their obligation to engage in disarmament negotiations series. And the court got rid of that case by indicating, well, the Marshall Islands simply have not, there is no dispute between the Marshall Islands and India and Pakistan. I mean, the only countries which ended up before the court were India and Pakistan. And they said, and you have not engaged India and Pakistan into sufficient negotiations. So Myanmar. So next stage in the Gambia-Myanmar case will be a decision on jurisdiction. I consider that the jurisdiction that the court will be positive, come out positive on jurisdiction. But of course, the big problem in the genocide cases is the very strict definition that has been established as to what constitutes a genocide. That is, and so unfortunately, no time today to go into this, but what my prognosis is, I hope not to be right, that the court will come to the finding what happened there is ethnic cleansing. It is terrorizing it's committing huge, cruel, let's say, tortures and killings, etc., etc. In other words, what you call crimes against humanity, but not genocide. And for crimes against humanity, the ICJ does not have jurisdiction, because the jurisdictional basis is the Convention Against Genocide. And so my slightly sad prognosis is that the court will end where the other genocide cases also ended, with the exception of this mini success for genocide in the Bosnia against Herzegovina. The Bosnia against Serbia case. So this is Myanmar. Then if the court comes out against jurisdiction, then the case will deal with the merits, and there you will have that problem that ethnic cleansing is not, of course, ethnic cleansing can be an element of a genocide actually happen. But if you find ethnic cleansing in a country, in a situation, this is not enough to prove genocide. That's what I wanted to say. Okay, so this has been a number of cases like going up, going up, going up. Then you had Georgia via Russia. Then you have going up again. And now that gets me to two cases which I also have to deal with, is the ICJ and human rights, where the claimant relied on human rights violations. The defendant, or the respondent state, relied on other, let's say, rules of international law, and the court did not come out in favor of human rights, but gave priority to these other more traditional norms of international law. And here you have two cases that are the last two in my let's say, tour d'horizon. And the first one of these cases is a case which again plays in the Congo, the so-called arrest warrant or Herodia case, which I mentioned just in passing at the very end of my lecture last night. So arrest warrant Herodia. What happened there? You had this civil war that I described yesterday, and you had these foreign troops in the country, troops from Rwanda, Uganda, etc. And you had that the wish of the Congolese government that they would leave now. Would you please leave? They didn't leave. And in that situation, the foreign minister of the Congo, one Mr. Herodia, made a speech in the radio and said, if they don't want to go, we have to throw them out. So go out on the street, and wherever you meet any of these, just drive them off, kill them if necessary, etc. And this was regarded, now we looked to Belgium again, by one of these fiery left-wing, probably, juges d'instruction as a violation of human rights, namely some kind of a let's say, Aufruf, how would you say, exciting people to engage in genocidal acts. And the Belgian judge, rendered another international arrest warrant. Now you can imagine how a country reacts if an international arrest warrant arrives against its own foreign minister. And so Congo went before the ICJ against Belgium. And the court decided the case, I think in 2002, just a year before I joined the court, in the sense that it said, no, this is really a violation of international law by Belgium, because Mr. Herodia was a foreign minister. That is one of the highest ranking civil servants in the country, an organ of the state. And this organ of the state enjoys immunity. And Belgium has breached the right to Congo, the right of the Democratic Republic of Congo, to see that it's the head of state, the head of government, and foreign minister can enjoy that immunity. And I just read from the judgment just a small part. So the court says, but don't get me wrong. Immunity does not imply impunity. There are circumstances under which a foreign minister can end up being in a criminal proceeding. And the court says as following: the immunity is enjoyed under international law by an incumbent or former minister for foreign affairs, actually square brackets. They brought, when that case was brought, they changed the job for Mr. Yerodia from foreign minister to minister for sports, because as minister for sports, you don't have to leave the country, and you're not in danger at some airport to end up in a cell because of that arrest warrant. Okay, so the Mr. Yerodia he said, this doesn't mean that this is not necessarily about the criminal prosecution in certain circumstances. Okay, what are these circumstances? First, such persons enjoy no criminal immunity under international law in their own country and may thus be tried by those countries' courts in accordance with the relevant rules of domestic law. Because, diplomats, etc., politicians, depending on domestic legislation, can be prosecuted in a country. The rule is, and I think the better, but I don't want to give you any hints as to situation in your own political system. But the better view is that they can be prosecuted and brought to justice in their own country. Secondly, they will cease to enjoy immunity from foreign jurisdiction if the state which they represent or have represented decides to waive the immunity. That is also possible. Thirdly, after a person ceases to hold the office of Minister for Foreign Affairs, he or she will no longer enjoy all of the immunities accorded by international law. That is, once out of office, the person will not. And then comes a sentence which I consider to be problematic. It says, provided that it has jurisdiction under international law, a court of one state may try a former Minister for Foreign Affairs of another state in respect of acts committed prior or subsequent to his or her period of office, as well as in respect of acts committed during the time that guy was in office in a private capacity. And these last words to me are very problematic. So what does the court say? It says, of course, such a former foreign minister can be tried by another country for acts that he committed before becoming foreign minister. No problem. Subsequent, yeah, okay. And then you have the case that says you can also try that person for acts that he committed during the period in office in a private capacity. And if you look at persons like Pinochet, I think the Pinochet case is probably but other cases like Habré, etc., you would probably conclude that the violations of human rights law committed or instigated, directed by these people, are not done in these people's private capacity. They are done. Pinochet was able to do what he did because he was the ruler in Chile, and the same is Habré. You cannot say then after six you engage in human rights violations in your private capacity. You might have heard of the case of Filartiga versus Peña-Irala, which was one of the human rights cases in the domestic law of the United States, where the court made a similar distinction, and I find these distinctions are nonsense, actually. So this is my criticism of the arrest warrant case. And then we get to the last case I have on my list here, and this is a case which concerned my own country. It was a case which Germany brought against Italy. It's the so-called, it's called the jurisdictional immunities of the state, brackets, Germany v. Italy. And what was the problem there? The problem was that the situation that during World War II, during the first years of World War II, Italy was fought on the side of Germany against the Allies. In 1943, the situation had become so bad for the Axis powers that Italy, let's say, threw out Mussolini and became and concluded an armistice with the American and the British troops. The Germans regarded this as, of course, treason, and from 1943 onwards, former members of the Italian armed forces and other people in Italy had terrible times because the Germans were driven up, more or less, up to northern Italy in the 1943-44 till early 1945. Italian partisan troops fought the Germans. The Germans committed terrible crimes. Whole villages were eradicated, killed, people driven in the church set in flames, etc. Terrible, terrible. And hundreds of thousands of Italians were taken to Germany and were forced to do forced labor under circumstances which many did not survive. Now, strangely, after 1945, there was no big fuss about these things. In a way, both states wanted to forget. And a peace treaty was concluded with Italy in the late 1947, actually. But the peace treaty was concluded between Italy and the Allied victors of the war, and Germany was not a party. And in that peace treaty, Italy committed itself not to engage in its domestic courts, not to bring Germans or Germany to court. All right. Now, in the 1960s, Germany paid, I don't know, sums which to me are probably peanuts compared or in relation to the terrible crimes that had happened to countries like Greece and Italy, also for reasons like the mistreatment of local populations during the war, etc. Okay, and then you suddenly find in the 1980s and in the 1990s, you find that former prisoners of war, former forced laborers, or family members of people who had killed by the German armed forces, by Gestapo, SS, etc., went to the Italian courts and said, I want to sue Italy. I want to sue Germany for crimes against humanity and war crimes. Actually, the same thing happened in Greece, where the German troops had behaved equally atrociously during World War II. And then you had domestic courts rendering judgments in favor of the claimants and saying, yes, we are aware that Germany is a foreign state, it's a sovereign state and enjoys immunity. But this immunity has limits. And the state which has committed the acts like Germany did in World War II simply does not deserve to remain immunity if crimes against humanity, war crimes are the subject matter of these cases. And so this went to the Italian Corte di Cassazione, which is the highest, which is the Supreme Court, except constitutional matters. And the Corte di Cassazione rendered such a judgment. I remember I was in Germany, of course, at the time, and I had a lot of work to do in the Foreign Office. And I remember how concerned the German Foreign Office was with these developments, both in Greece and in Italy. Then I left. I went to the ICJ, and then the situation got so bad that Germany decided it would now sue Italy before the ICJ, and then sue for breaches of the immunity, before Italian courts that Germany was entitled to, also for the acts of World War II, etc. The strange situation, this is really very strange, and I think but it is important to. The strange situation was that the Italian government, while politically, was actually on the side of Germany. So just imagine you have domestic courts in Italy rendering judgment and saying, therefore, judgment is liable to pay. And they were already in northern, on Lake Como, which is a beautiful lake in northern Italy. There is a big villa, or it's almost a small village. I've been there, which belonged to Germany. It was donated to Germany by some Italian friend of Germany, apparently. And they had already gone to the local court and kind of attached, and said, marked this property for execution in favor of the claimants in these cases. Germany said, and the Italian government said, we are very sorry. And we said, we are not in favor of that. Why? Well, Italy was afraid that the same thing might happen to it in other countries like Libya. In the 1930s, Mussolini thought it's high time for Italy also to get colonies. So they brought a war against Abyssinia, Ethiopia, and they engaged in decades of warfare and violations of human rights in Libya, among others, hanging the local leader in Libya, etc., etc. I don't know, of course, you are a bit farther away, but I remember at the time when, what's the guy in Libya, the dictator, with the beard, etc. God, but you know whom I'm talking about. He was invited.
Gaddafi?
Super. Who?
Muammar Gaddafi?
Gaddafi, right. Sorry. Thanks for helping me. So if Italy needed Libyan oil, and so invited Gaddafi and, invited him with all honors. And I remember when Gaddafi left the plane on Rome airport, he had a picture of the former Libyan leader of the 1920s and 30s that the Italians had hanged. So Italy thought, if we support that, that movement of our courts, the next thing that is going to happen is that these Libyans and Ethiopians are going to sue us. And so you had this very strange alliance between the German government and the Italian government against the Italian courts. Now, the International Court decided in favor of Germany. And I think I was on the court, and I can really say it's my honest opinion that the court did not have no other possibility without bending international law on the matter. I tell you why. The court had to establish its jurisdiction. The jurisdiction was based on the European Convention on the Peaceful Settlement of Disputes of 1957. This convention says that you cannot go to the court in cases, and I quote, for disputes relating to facts or situations prior to the entry into force of the convention as between the parties to the dispute. And Germany claimed, and the court said, yes, of course, the World War II and all these things were facts or situations prior to the entry into force between the European Convention of 1957 between Germany and Italy. I think that entry into force had been in about 1961 or so. So that meant the court could only decide on things. Let's just imagine you are in a theater, in a performance, and down comes the jurisdictional, what would it say, the wheel, You mean you don't see beyond 1961. So what do you see? You see Italian courts not respecting the sovereign immunity, the jurisdictional immunity of Germany. And the court said, unfortunately, it didn't say unfortunately, but this is what I can look at. Okay, and now Italy made a number of claims into which I cannot go. Territorial tort principle, the special gravity of the violations of international law, the fact that the Italian claimants had no other legal avenue available. So there's simply a huge problem of due process, etc., etc. But the court said, well, what we have to look at is there a rule of international law on which we could rely in sentencing and denying the German claim? So the problem for Italy was to establish a rule of customary law. There was no treaty, there's no treaty of customary law, which would allow domestic courts to make an exception from immunity in cases like that. And if you look at that, I think there is a really fine, cutting-edge analysis of the state of customary law on the matter. And the state of the customary law was, yeah, you have cases here and there in a couple of countries, but there is no, let's say, general opinion that the law is to change on such matters. And so the court decided that on the basis of customary law, Italy had breached the right or the entitlement of Germany to immunity. But it did something else that is. So the court looked at the legal situation in a way. I don't want to turn the court into a person, but you could say, of course, the court was aware it is not a beautiful situation in which you find yourself to just say, okay, just kind of go with the human rights violations like this. And so the court said two things. It said, Germany has rendered financial compensation to hundreds of thousands of persons, especially in Eastern Europe, who had suffered from German occupation or persecution. The only group of victims of Nazi crimes are these few thousand Italian military internees or civil internees that the case was about. And then the court says something. The court said, and in that situation, we express our surprise and regret that Germany did not see itself in a position to also compensate these victims. And this is something which I find extraordinary. There's an international court, full of respect for sovereignty, blah, blah, blah. It says, Germany have won, the Italians have breached. But we are surprised and we regret that you haven't really found a way to pay a few millions to these Italian victims. This is extraordinary. And please regard it like, the steam building up in the court. God, we are bound, if you don't want to bend the entire theory application of customary law, we cannot come to another conclusion. But we're going to tell the Germans that we really, you could have done better. And a few paragraphs later in the judgment, the court also says, this judgment is not supposed to stand in the way of negotiations between the two countries which aim at the satisfactory settlement of that dispute. This, so why don't you just engage in negotiations and create of course, Germany has in all of these cases always, and actually the latest development in that regard is just at present. I don't know whether you read in Brazil about these matters, but there has been a development at the end of which Germany has now recognized that Germany before World War I, at the outset of in early 1900s, committed a genocide against the population in Southwest Africa, the so-called Hereros. They say it's not a genocide in the technical sense, because the Genocide Convention was only adopted in 1948, which to me is a silly argument of my own Foreign Office, because, what happened in 1948 was that something was, let's say, put into a legal vessel, so to say. But of course, genocides happened before, like the one on the Armenians, etc. So, but otherwise, this is the first time, and Germany does so with very little steps. And of course, the decisive element is money, because Germany is afraid that if the Greeks, if the Italians, if the Poles, if would come and say, actually, again in square brackets, both Greece and Poland have made claims at the political level, especially left-wing governments who consider that Germany is exercising too much power in the European Union, is just being too mighty. They say, by the way, I think you still owe us 380 billion Deutschmarks from World War II. And if you, of course, if you started counting the damages that Germany caused in Poland, I think Germany would probably be broke. So Germany is always well aware and says, okay, we'll have a commemoration, we'll establish a foundation looking into the history, but what we do not want is simply pay. And of course, for not paying, they have good reasons, as the court also showed, but on the moral level, the German position is not very impressive, I have to say. So personally, at the big conference in that Villa Vigoni on Lake Como a few years ago, in the presence of all kinds of government people from both countries, I had just read the Frankfurter Allgemeine Zeitung, our main newspaper, of the day before that conference, which had said that the Germans are getting, I think, 50 billion more in taxes than they expect. And I said, why not take 1% of that money, establish a foundation which is carried by both Italy and Germany, and really give these people some money. But nothing has happened. And the reason why nothing has happened is that the German government is afraid if they give in this regard, which wouldn't be terribly expensive, then the others would come and say, me too, me too, me too. But in the financial sense, of course, me too. All right, so this was my, let's say, march through the case law. Now let's see how much time have we left. About maybe 15 minutes or so. So let me just say a few words about the context of all of this and consequences and limits, etc. Now, is the question, is it a good idea to bring human rights cases before the court? And my view would be, well, I mean, if you have a good case, if you have, let's say, if you really can convince that there is a jurisdictional basis, there is a dispute, and you are serious about it, and you are not afraid of the costs, then it's a good idea. And that it's a good idea, you can see in the Gambia-Myanmar case that both the Netherlands and Canada have declared that they are ready to join the Gambia in their case against Myanmar. And I think they might even do it. So this is a growing movement, and I think this is a good idea. But of course, never lose sight of the fact that the court, that you always have to find the jurisdiction. For instance, there is no jurisdiction of the ICJ for crimes against humanity. There is the Genocide Convention, but you don't have so the only way of doing something legally against crimes against humanity would be to go to the International Criminal Court. But this is this is just another procedure, and it's not a state-to-state procedure, of course. So just keep in mind the limitations of jurisdiction. Then, in a way, I don't know if you. I mean, the court has a good website. Actually, you can see let's say deliberations, etc. And so what do you see? You see the court, you see these 15, maybe 16, 17 people kind of trying to, remain attentive, etc. during these hour-long sittings. And then you see the teams of the states. Then you see some observers, diplomatic corps, or maybe groups of students, etc. And the victim of the human rights violations are human persons, right? And the victims are not there as parties. And of course, This is a mix. So you could say before the ICJ, we are looking, when we look at the question of what responsibility does a state have for human rights violations against another state, we are in a way looking at the wrong relationship. This is interstate, and at the interstate level, human rights are kind of trying to force their way into the system, like in the ILC articles 48, etc., that I mentioned. But of course, it's not the natural habitat for human rights cases. The natural habitat would be regional or maybe even universal human rights courts, where the individual can bring his or her own case. And this is not the case. You need a state that takes up your case. Now, of course, the state willing to do so could be your home state. And then you have what you call la protección diplomática, diplomatic protection, very old-fashioned Mavromatis case and all that. And instead of claiming that the other state has violated your right to property, the state now claims the respondent state has violated human rights, a bit like in the Diallo case that I mentioned today. But it's not easy to find such a state. This litigation costs millions. You can lose it. And states in human rights matters are always, you could say, just thinking of a metaphor, you are always, it is not something that diplomats are excited of and rejoice if it goes another state for human rights violations, except you are in a Cold War, or you are the United States versus China, or the United States versus Russia, and then Russia retorts and says, look at all the people sleeping on the street in your country, etc., etc. That is, but usually it's not, diplomats want to be friendly, states want to be friendly to each other. Accusing another state of a human rights violator doesn't, let's say, make your friendship more intensive. And therefore, and the remedies, what kind of remedies do you have at the interstate level? Very few. Another point would be the parties, it's not you as the victim of a human rights violation. It will be the state taking up your case if you found such a state, which will frame the case. And depending on how human rights minded that state is, the more or less of the human rights will be the core of the application. And sometimes human rights, as the Georgia against Russia case shows, human rights violations are, well, you finally found them in a corner in the Convention on Elimination of Racial Discrimination. But your actual problem with Russia is not that people were driven from their homes. Your actual problem with Russia is that you hate them, that they take part of your country, like, Abkhazia, etc. So human rights are in danger of becoming, you could say, collateral topics on a theater of a political war. Okay. Now, what are the prospects for the future? One more point. I'm not sure whether the court is actually finds itself in a development away from that observation. But when I started writing about the ICJ and human rights, one point I made was the following. I said, if you look at international courts and tribunals, you find a growing number of tribunals that can engage in human rights cases. Inter-American Court of Human Rights, European Court, the Banjul Court, etc., etc. And in a way, you could say one reason for countries relatively not enjoying, but tolerating being brought before an international court is the Hague courts, respect for sovereignty, just the kind of reverence or what would the word be, hold back attitude that the court has. And if the ICJ in The Hague, which until now has always been respectful of sovereignty, respectful of immunity, etc., now suddenly takes a very progressive pro-human rights course that might cost the court friends. And then I looked into the current states that have gone to the court, and you find, for instance, I mean, now it's getting a little personal, but you find that the state which has engaged in most cases before the ICJ against neighbor has been Nicaragua. Nicaragua has systematically, you can say, tried to enlarge its boundaries around the country. And if you look at the human rights record of Nicaragua, not great. Another group of states which is quite active in going to the court would be African countries on boundaries. And usually, with all due respect, by human rights respect in many African countries, not really that great. So the point I want to make is these states might feel quite comfortable with a court like the ICJ. It's old-fashioned, but among diplomats, being old-fashioned means great. They respect you, they treat you better, etc., etc. So this is another reason. But some other people have accused me that this is simply not the case anymore. And let's see in which direction the court moves. So let me just conclude with a few words on what is a proper role of the ICJ. What is it? And here, I think the court has to be aware that there are human rights courts out there, like yours in San Jose de Costa Rica and ours in Strasbourg, who have developed their treaties and the treaty law of their conventions in ways which are remarkable, even though some countries like Brazil have not become parties, right? Is that still the case? I think it's still the case, but I think the majority has. And of course, the ICJ must be very careful not to, how should I say, be in the way of these developments by saying, well, we were on the basis of general international law, etc. And in general international law, human rights protection has not reached that state of progress that these people in San Jose think, that these people in Strasbourg think. And that would be very bad, actually, for the development of international human rights law. So leave the regional courts alone, don't mess in their business, and don't destroy the theories and etc. that they have established. But what the court can do well is to what I call the mainstreaming, to mainstream human rights. In a way, you could say there's this ICJ in The Hague, and there's these 15 judges, and the international law is fed by claimants and respondents through that court. And you can say the international law which survives the scrutiny of the ICJ and comes out in a judgment. International law is there, and it says that is some kind of that means that there is the last, blessing or final acceptance of human rights law in international law. So you can say, once the ICJ has recognized, for instance, the Aragonés character of a human rights convention, etc., this is a state of the law which cannot be pushed back anymore. So that's what I mean. So in a publication, I had the following final sentence, with which I'm going to conclude my lecture. There I said, what we can observe already now is that the ICJ has become a major player in a process in which human rights and general international law mutually impact upon one another. Human rights modernize international law. International law, represented by the court, mainstreams or domesticates human rights law. That is, it gives its blessing. Because if you look at, for instance, if you look at some findings of human rights treaty bodies at the United Nations, you see that their claims are made or allegations are made on existence of rules and of human rights which states simply do not recognize. They say, well, the general, let's say, the conclusion of the Human Rights Committee of the United Nations, this or that, I don't recognize it. It does not represent the law. It goes beyond the law. If the ICJ would say that, it would be very, very difficult for a country to make the same statement. So I think that is where I see the most important role of the ICJ. Terminado, obrigado, how do you say? Yes, that's it.
Thank you, Professor Simma. It was fantastic. I had one question already, and when they are preparing another, I'll tell you that Augusto Carijó sent us a question that is, Professor Simma, it's a pleasure to hear you. If the jurisdictional prerequisites are met, do you believe that it would be possible for a third state to bring a case up on the ICJ regarding human rights violations during the pandemic? By third state, I mean similarly to what the Gambia did against Myanmar. I think, Professor, you already said that, but I'd like to point this question and back to you. Thank you, Professor.
Of course, what I would like to know is what would be the claim of course, one thing is the naming of that state as a third state is in a way misleading, because you can say if super farmer A has a problem on where his let's say estate ends and the other starts with super farmer B, so you have state one and the first state and the second state, and the other neighbor would be the third state. In human rights, where you litigate a collective interest, there are no third states. There are simply, let's say, affected states, etc. And then, of course, the question would be that I would like to know is what would the claim be? What violation would that state claim? What could that be? I mean, you could probably think of some Americans or who would say, why not bring a claim against China for having, well, I mean, this is not my view, okay, don't get me right, but there were people who said this was planted intentionally in the course of China becoming the hegemonial worldwide. I would say if there is some truth to these things, it might be that the let's say civil servants like professors and natural scientists in some institutions did not display sufficient diligence and let one of these viruses slip, etc. And there, of course, there would be possibility for a legal case, for instance. Another possibility, but I wouldn't give it much chances, because in the practice in these cases, as I find out in the Iran-US Claims Tribunal and in the investment arbitrations that I do, is always the causation. You end up with huge problems of causality. Would you please prove that this thing escaped in this at this let's say laboratory here and there, etc. Very, very. Would you please? How would you? For instance, in climate change cases, how would you divide up the responsibility for climate change? That Germany pays 20%, the UK is even more burning, let's say, who is burning coal? China is the greatest exporter, Australia is the greatest exporter of coal to China. So, I mean, how do you share the responsibility? Very complicated. Another possibility would be, so I wouldn't consider, I wouldn't give these claims, litigations a big chance. Another possibility would, of course, be that the provision of vaccines, if used as a political tool, could become interesting from the viewpoint of also of international law. I've just before I prepared for my class here, I've come across a piece in the leading newspaper, here, which says the problems that Taiwan had obtaining vaccines because of Chinese resistance. So a very complicated procedure had to be done in order to provide vaccines with Taiwan. If Germany had simply said we are going to send Taiwan, I don't know, 10 million shots, then big problems with China. Of course, legally speaking, the question would be, if you do not deliver vaccines, even though you would have it, you, for some reason, because you don't like the other country, etc., etc. So when you talk about it, you find a number of situations where COVID-19 has a legal aspect, but I think it will be very complicated to really make a firm legal case out of it. I know that on every international law blog, this is a topic now, but I think maybe some other questions could go into the direction, make the problem a bit more, let's say, having contours.
Thank you, Professor. I agree totally with you. Thank you. I think now the floor is open for you if you want to.
I can spend another half hours or so if questions happen to be there. If, of course, I have satisfied everybody or people have fallen asleep, then it would be another matter.
It was fantastic. I was going through a foreword that you wrote some years ago in a book called International Law and Sustainability Development, Principles and Practice, from Nico Shriver and Friedel Weiss. And you wrote there that here, and this is very interesting for me, major concerns as well as interest is beget ideas, then concept, principles, eventually practice of law, at least sometimes. These are the familiar ways of all law, including international law, everywhere and at all times. And you told us this today and yesterday. That was fantastic.
Was this a paper in which I wrote about the ICJ jurisprudence and environmental?
It was a foreword that you wrote in this book.
Yeah. When you reach a stage in your career and in your life where people don't expect you to write decent papers following the Harvard, the Blue Book. They say, we know that he's not going to do that. Or if he produces a paper, then maybe it has been written by some let's say, slave, some academic slave somewhere. So what are you asked? You are asked to write forewords, or what? You write these blogs at the backside of a book, just got this book on breach of treaty, which is one of my favorite topics, actually. Just got it this morning. And there are these blogs at the back, like Professor Cantado Trindade says, this is a book which finally agrees with me about how human rights have won out. So I can only tell people, you have to read it, otherwise you'll miss something. And then Cantado Trindade or Bruno Simma, etc. So these blogs, so I do that for friends, and of course you always get the book once it comes out, and so that's nice.
Thank you.
But I thought that in this book I had written, there's another publication where I wrote a paper on also international jurisprudence of the ICJ on environmental law, which would also be interesting. But I just chose human rights as my favorite topic.
Fantastic. Thank you, Professor. Murilo has a question. Murilo, the floor is yours. Thank you.
Oh, Murilo, please.
Please, Murilo, please.
Where is he? Murillo?
Oh, yeah.
Hi, no question.
No question.
No questions? Oh.
How about the ladies? Leticia, a question?
No question.
No?
Everything. But
Mariana?
I was going to ask about your opinion on human rights future, but you have already talked about this, so thank you very much.
Boy, what a feeling. I've solved the human rights situation in the world. Well, I hope I have. You have to do your little contribution to that. Tatiana, any Tatiane? Or is that Tatiana?
It's a Jenny. No, I have no questions. I'm just trying to understand everything that you said.
I think that's probably the difference.
A lot of information.
Yesterday, I was told that you're going to be a bit late because there is Professor Alain Pillet still answering questions by students. Then I looked at the topic that he was teaching, and the topic is practicing international law. And of course, I can imagine that this creates questions because more or less, what can I do in order to end up practicing international law? So this is really a very, let's say, whereas questions on some other topics are more difficult. But maybe Deborah, you have a question?
Actually, Leticia has a question. She asked, what do you think about Brazil's application of human rights?
What do you think? Sorry, I didn't understand. What do you think about Brazil's application of human rights? This is the type of questions that I really do not want to answer because it's first of all, of course, there is always a lack of actual knowledge. I mean, I've never done a study on Brazil and human rights except reading the newspaper, and there you get some ideas. But I don't want no, thanks. I simply am not. I do not know. I do not know enough. But don't get me when I say I do not know enough about the situation that I want to avoid. I think there is a lot of problems there. Like I could also speak about human rights violations or problems in Germany. So every country, I think every country in the world has human rights problems. And for every government in the world, actually, this is things that I have written. I think you can find human rights arguments and human rights on a scale from being a pain in the neck to a threat to a system. And I would say, fortunately, my own home country, I'm also Austrian, are two countries who will all speak out for human rights and the foreign minister and blah, blah, blah. But they have their little, let's say, skeletons in the closet. And when they would curse and say, Simma has his mouth wide open, etc., or Amnesty International, etc., etc. Even Germany, even Switzerland. You don't find a country. And of course, on the other hand, you have systems which will suppress human rights movements or disappear human rights defenders because they know this might bring my reign to an end. And I think that is the truth. And that, of course, I think I started my lecture yesterday. And remember, I said, I've never been. Of course, I donate money to Amnesty, etc., etc. I do all of that, but I'm not I shouldn't say that as a man. You probably should say Simma should be a fighter. He should be an activist for human rights. I simply haven't been. I've always been concerned, but as a professor, I thought if I can contribute, if I can do something useful and sensible, I just write about it. It makes no sense if I stand there in the street or throw a rock at the police. It just makes no sense. Actually, I was very bad in rock throwing already in school. So so everybody, yeah, I forgot now what I wanted to say, but I think you got the idea. You got the idea.
Yeah. Yes, I got the idea, and I liked very much the way you position yourself as each of us has to play our own part in defending human rights. If we're a scholar, then we'll do scholar work. If we're activists, we do activist work. I think that's very adequate.
Yeah, good point.
Thank you.
And Professor, we had another question from Mariana.
Okay.
Mariana, please.
Hi. we would like to know the name of the book, the title of the book that you have shown us.
No. It's called, you mean this book?
Yes.
It's called The Breach of a Treaty, State Responses in International Law, by a Greek scholar teaching in London by the name of Maria Xiori. And I got it, even though it cost 120 euros, which is really a lot of money for a book, because Breach of Treaty has been one of my favorites. My very first paper in English was in 1968, published in 1970, probably before your parents were born, on Breach of Treaty and responses. So this is, you have your favorites, you know, like, what is it? On revient, as the French say, on revient toujours à ce premier amour, at your first love. So this is Breach. Sounds a little sick to say that Breach is my first love, but again, you know what I mean.
Thank you, Professor. Deborah, please.
Yes, this question is actually mine, and your reply as to activism and positioning oneself within defending human rights got me thinking, as Brazil is a country that has very controversial public opinions about human rights, and that, in my opinion, derives from the distorted view that most people, or some people within certain circles have of what human rights mean. And do you have any advice or any views on how one can educate more people who aren't academics or scholars, or actually in the field of social sciences, as to the importance of human rights, how to, in layman's terms, try and educate more people about that?
Well, I think the only thing I can say is that, of course, education and inclusion of some basic human, let's say, knowledge of human rights in the syllabus of schools, starting from primary schools, is not just a good idea. I think it is actually almost necessary. I remember I dealt with that in the first practical work I did, which was at the United Nations as a member of a committee on economic, social, and cultural rights. And in there are provisions. When we dealt with cultural rights, we also dealt with human rights education, and we compared countries, etc. And I think in some countries, efforts are made in that regard. Actually, I found out, I mean, I asked my students here in Germany, or I asked just people I know from my family, like, let's say, my son-in-law, etc. Have you ever heard about human rights in school? And actually, they have. I don't know how interested they are at the age of 17 in human rights. But I can only say, and of course, I speak in a privileged position, that you really, when you, for instance, how valuable a human right to be able to express your political opinion is. You probably do not realize how valuable it is, as long as nobody is against you and you can say anything, as is the case in Germany, except you have to put the little asterisks and also to include women and transsexuals, etc., etc. But this is, in a way, is ridiculous compared to situation in other countries where you disappear from the service of the globe if you speak out the wrong, let's say, the wrong opinion. And of course, I do a lot. I study a lot. Well, maybe I shouldn't say that, but the older I get, the less legal books I read. And the more interested I get in, let's say, politics. And just, I was born in 1941, and to me, just think, Bruno, you have been around during 4 years of World War II. You have been around. I mean, I was small and everything, but you have already been there. So what made people behave the way they did? What did they know about concentration camps? Can you really say, no, people, and I remember my own stories. Like I remember I grew up in the western part of Austria, and I had the war was something far away. The only thing, I lived in a beautiful villa which had a copper roof, and so usually you had American planes, and they loved that copper roof and fired their machine guns into the copper roof. But we were sitting in the cellar, and I found it very funny. And years after, I found in the attic of our villa, I found the not bullets, but the shells that were stuck in the wood, etc., etc. So this is a very, how should I say, anecdotal way of. But I remember a scene where my mother took little Bruno, maybe at the age of 3 or 4 years, on a walk, and suddenly I saw a group. I remember seeing a group of people coming our way, dressed in pajamas. And I asked my mother, Mama, what are these people? And my mother said, oh, let's turn away. Don't look at that. And she turned around, and we went off. And then I learned later on that this was a small concentration camp right there in the neighborhood of my hometown, because Germany had hundreds of concentration camps, not just the Bergen-Belsen, Dachau and all that stuff. So I have had some, and then you live in a free society, and you think you should really be ready to fight for it. And if you can afford in some way, maybe by donating money, or giving a speech, also fight that other people in other countries have the same possibility, just to live a free life, express their political opinions, and be free of fear.
Thank you, Professor Simma.
Thank you so much for sharing with us that experience.
Thank you, Deborah. Ursula Mina.
So maybe this was a good and dignified way of concluding this lecture on human rights. So what are you going to have next? Is there another lecture following mine now? What is this
yes.
about?
Professor Bruno, we have a last question from a student. Would you accept it?
Yes.
Okay, Leticia.
Hi. It's going.
It's a little difficult.
I guess her audio is not working well. She froze.
To be very fast, I promise.
Can you start again, Leticia?
Can you hear me?
Yeah.
Yes. Do you hear me well? Okay. First of all, I would like to greet Professor Luís. I have had the pleasure to meet him while I was still in law school in my hometown. And also my first chapter in a book was with you and other very great professors. So my greetings. And second of all, I would like to greet Professor Bruno. It was an amazing lecture. And my question is more of an opinion question. I would like to know, how come do you think that populism and nationalism influences the effectiveness of human rights application?
Well, I think it affects it in a very negative way, because nationalism and let me focus on nationalism. Nationalism will always have the effect of considering that the group you belong deserves rights or positions, entitlements that others do not deserve or not deserve in the same way, that you are more important, you are in the center. And of course, this is against a very basic realization that is behind human rights, namely that every human being has a dignity. And it's very difficult also for me. You see, for instance, what you find on the streets of München München is a very opulent city and it's very saturated, and you can say it's, compared to Berlin, it's a city where people are fat and lazy. They have everything they need and there is no fire. Maybe in Berlin there is more of that, right? But you, for instance, you see beggars. They sit around, but you know that these beggars are organized. There are organized groups from Romania and Bulgaria, among other, in the first instance. So these poor people sit there and they have to deliver the money to their leaders, etc., etc., etc. So, and then for somebody who just walks by to develop the view that, what should you do? Is this something that you should respect, or maybe say, irrespective of where the money goes, I'm going to give that poor woman that. So those are the, let's say, luxury human rights problems that people have in my country. You know, I mean, belonging to I'm probably upper middle class. I have a very good income, etc., etc. But also in my country, there is nationalism. There is a new neo-nationalist party, and some of their leaders sound like the National Socialists in the early 1930s. So their populism, it's not, to me, I have problems with the term populism because it's used in by many people against many other people. And sometimes person A says person B is typically populist, isn't she? And I think, well, what do you mean? Is it just because you don't like what she says? An argument. So a populism is something which is a bit like a squid in my hands. It's very, as they say, it's about as difficult to get hold of populism as nailing a spaghetti on the wall.
Thank you.
Apropos spaghetti on the wall, I remember my wife telling me we have a dinner invitation tonight, so maybe I move from human rights to spaghetti.
Professor Simma, thank you so much. It was fantastic. I'd like to thank everyone here too. Professor,
I'd like to thank you for the invitation, especially Professor Leonardo Brandt. And I hope to be able to return to Brazil in the near future. Maybe if they continue their winter courses the way I remember 1905. No, not 1905. I'm not that old, please. But 2005. I remember the time I had in Belo Horizonte.
It is fantastic.
I'm not going to give you any details, but I have a great. Thank you very much. Thank you. And bye-bye. And good luck to you.
Thank you, Professor.
Keep away from the viruses. Good luck to you. Bye-bye. Thank you very much.
Bye-bye, Professor.
Bye-bye. Thank you.
Bye-bye. Thank you. Thank you very much.
Bye-bye.
Bye-bye, bye-bye. Obrigado, gente. Tchau, tchau.